Just while you're munching your sandwiches and those Nanaimo bars, which I highly recommend, I hope you got one in your lunch. I wanted to take this lunchtime working session as a chance to give you a sense about where this Environmental Bill of Rights project is going, because it promises to be the next major initiative from the government. For those of you who follow things like throne speeches, people in government tend to live and die by what's in the throne speech. If you can get a project you're working on mentioned, it can give you the right sort of momentum to keep things going within government. That's exactly what happened with the most recent throne speech. There was a little one-line reference to the fact that Ruth Greer, Minister of the Environment, was expecting a task force to report on the issue of an Environmental Bill of Rights and to have a bill by the end of the year. What I've had copied and distributed, if you picked up that package as you were going out to lunch, there's a copy of the two pieces of legislation, the Class Proceedings Act and Bill 29, the Law Society Amendment Act. But also underneath all of that, there's a one-page copy of the task force's terms of reference on the Environmental Bill of Rights. And behind that, there's a copy of the statement that the Minister of the Environment made in the House on October 1st, 91, talking about the creation of the task force. And there's also a copy of a information flyer that was handed out by the Ministry of the Environment at the time the announcement was made. This is really all that's been made public so far on this exercise. And one of the reasons I got involved in it as a co-chair, along with Gary Posen, who's the Deputy Minister at Environment, is that we wanted to try and recreate this successful mediation of a public policy dispute in a task force. The Class Action Advisory Committee was exactly that. We sat around a table and everyone explained what their various interests were, and we tried to meet them legislatively. With the Environmental Bill of Rights, it's a very similar exercise because there are some very diametrically opposed views on whether there's even a need for a Bill of Rights, and assuming that there is a need for it, what should be the content of it. Ruth Greer made the political decision, as is her right in this in our system of government, that there's going to be an Environmental Bill of Rights in Ontario. The debate about whether there should be one is really over. She asked a group of people who are key stakeholders in this area to sit around a table and tell her what the content of a Bill of Rights should be. The stakeholders are mentioned in the press release, but just to give you a brief glimpse of the kind of a grouping that we've got, again, we have a representative from the Canadian Manufacturers Association, the Chamber of Commerce Ontario. We have somebody from the Business Council on National Issues, which is unusual because that's a national business organization that doesn't usually participate in provincial reform issues. They felt that the Bill of Rights was significant enough that they wanted to have somebody in on the ground floor with it. And Bob Anderson, who's Vice President and General Counsel at Procter & Gamble, is the BCNI's representative. We also have a lawyer from the Ministry of the Environment. We have Paul Muldoon from Pollution Probe, Rick Lindgren from the Canadian Environmental Law Association, and Andy Roman, as I mentioned, is there as a legal consultant to the task force because he has a very nice continuity in his participation in some of these task forces because he was involved in class actions, he was involved in the Standing Advisory Committee at the Ministry of the Attorney General, he was a consultant to the Law Reform Commission on these issues, so he has a certain area of expertise that's been of great assistance to the task force. My job really is sitting there as mediator, trying to get them to find the middle ground so that we can get unanimous support for the content of this particular bill. Part of understanding where this is all headed means having a pretty good handle on where it's been. people have characterized the need for an environmental Bill of Rights as really a political exercise, that it ends up being a lot more rhetoric than it does substance. There have been 8 or 9 private members' bills introduced to the Ontario legislature over the last several years. All parties have got in on the action. Ruth Greer, however, probably got the most publicity with Bill 12, a private member's bill, Environmental Bill of Rights. And in the private members' bills that have been circulated, and in Ruth Greer's Bill 12, there was talk about the need for class actions for environmental claims. And back when we had the Attorney General's Advisory Committee struck on the class action issue, we agreed within government at the time, when Ian Scott was Attorney General and Jim Bradley was Minister of the Environment, that the need for class actions wasn't something that was confined just to the environment, that if we're going to have reform for class actions, it should be a generic procedure available for all causes of action. And for that reason, Jim Bradley put the interest in the environmental class action on hold until the Attorney General's Advisory Committee could finish its work. So the only point I want to make here is that the need for class actions in the environmental field has been met already by Bills 28 and 29. That was one important piece taken out of an environmental Bill of Rights. Was there anything else that was broken that needed to be fixed by an environmental Bill of Rights? That's really what the debate has raged around for the last year and a bit. What we decided in putting the task force together is that we would take Bill 12 for what it was worth. The use of it even as a lightning rod for discussion around this issue has been extremely valuable, because it's made people stop and think about what's broken with the environment and environmental protection. But we realized that it wasn't the be-all and the end-all of our thinking on what could be an environmental Bill of Rights. So what we did is we used that really as a starting point. Once the task force got around a table with these terms of reference in front of it, you'll see that it's divided into 2 parts. Part 1 is a description of what will be in an environmental Bill of Rights. Part 2 is a list of tools that we are trying to use in the task force work to achieve those principles that the minister has told us must be in it. I've met with I don't know how many, part of my job as chair of this task force is to go around and meet with different groups, and I've met with the Ontario Federation of Labor, Ontario Mining Association, the forestry industry, Sierra Club for environmental interests. I've met with it's a very active temple north of Toronto, Temple Emmanuel, that has an active environmental committee. I've met with them, trying to get a flavor for what people think the point of an environmental Bill of Rights should be. And I generally have a lot of fun reading out these principles that must be in the bill, because I haven't found anybody who disagrees with any of them yet. The public's right to a healthy environment. The enforcement of this right through improved access to the courts and/or tribunals. Increased public participation in environmental decision-making by government. Increased government responsibility and accountability for the environment. Greater protection for employees who blow the whistle on polluting employers. Now, as I say, it's hard to disagree with any of those. Where the disagreement comes is in Part 2. How do you do that? Some of the issues that were raised by Bill 12 and which we have had to tackle in the task force is, do we have, for example, the concept of a public trust recognized in government? In other words, we say specifically and legislatively that the government holds the entire environment, not just public resources, but all of our environment, in trust for the citizens of the province. And if they don't meet their trust adequately, there's a consequence in a courtroom. Do we instead say that the public is the primary guardian? Individual members are the primary guardians of the environment, so that where there's environmental harm occurring, it's not the government that should be pouncing on the harm, it's the individual citizen who should have a right to sue and that we should have, and that's really where the concept of an environmental Bill of Rights came from, is that we would give people rights to protect the environment. We'd all have our job to do. It's another thing to say that there should be expanded or increased access to environmental decision-making in government, but what does that mean? If you ask people on the street what it means to make a decision in government, they have absolutely no idea even what the general categories are. I've been lucky enough, from my insider's view for the last few years, to know that government tends to make decisions in three big categories. They make policy decisions, they make regulations, and in the environmental field, the government, and by government I mean all the different ministries, issue about 3.9 million instruments a year. Instruments are things like certificates of approvals, licenses to cut timber, permits to get into provincial parks, fishing licenses. All those things are instruments that are issued by government every year. And if you said to the public, those are all environmental decisions, because the decision to allow somebody to fish and the extent to which you let them fish, the number of people you let into our public parks, the number of the approvals that you allow Inco to have for its stack in Sudbury, the approvals that are required for restaurant fans, all of those things are environmental decisions. And if you say to the public, the government makes 3.9 million of those decisions every year, and you need to be involved in every single one of them, most people, I think, would say that they don't feel like they need to be involved in every single one of those decisions. And the other part of it that we in government understand, or at least when I was in government, understood, was that you couldn't possibly build a system that will allow people to participate in every single one of those decisions. So as we moved through the different issues on this, we tried to come up with a set of recommendations that would capture some of these tools in a way that could realistically be achieved within government. It was affordable, that would allow the public to have some meaningful role in protection of the environment, but would also put the responsibility where it truly should be. And that is making a choice between individual citizens having the job of protecting the environment or the government taking the responsibility. So what I propose to do is at least describe for you some of the choices that this task force has to make to give you a sense about where the big decisions are looming for us. And I really can't tell you exactly what the consensus is of the task force because, first of all, it's not finished yet. And the other primary reason is that we try to keep our work and our decisions confidential until we have a whole package. That way we don't disturb our own efforts to build consensus. But I won't be letting any cats out of the bag if I tell you that the areas that we've really zeroed in on are solving this idea of who has responsibility for the environment, who has primary responsibility for the environment, how that primary responsibility should be described in legislation, how do we get the public involved in these decisions that are made, do we need some kind of increased access to the courts for litigants who want to protect the environment, and what do we do about the workplace to make sure that people who are out there in the workplace and see harm and want to report it can do so with some security that they're not going to lose their job over it. So those really are the 4 or 5 main areas that we're looking at. And as I say, what I'd like to do is give you the choices that we're facing. If you have any thoughts on this at all, I'd be very happy to take it back. I neglected to mention that part of the consultation that I do is with the Canadian Bar Association and with the Advocate Society. They've had some confidential briefings on the direction of our work and have been a big help. But let's just start off with this problem of the choice of responsibility for protecting the environment. If we have a Bill of Rights, it has to be a right for something. Should it be a right for individual people to dash into court and enjoin polluters or people who are committing environmental harm from carrying on their particular business or activity? Or should the responsibility be placed on the shoulders of government, and if government fails to meet that responsibility, it then falls to individual citizens? That's the key choice that we have to make. In the area of public participation and decision-making, one of the areas that we've looked at is not just the sheer volume and types of decisions that are made in government about the environment, but the significance of them. Most people don't care about the fishing license. Most people don't care about the provincial park pass. They do care about the Inco stack. They do care about whether or not a particular kind of plant that's going to remove, we'll say, some chemical from recycled batteries. They care about whether or not that plant is going to be allowed to set up in their neighborhood and what is going to be discharged into the atmosphere if they're able to do it. They do care about things like the Hagersville tire fire and so on. So if those are the kinds of significant environmental decisions that are being made within government, how do we get the public involved in those decisions, and what do we mean by the public? I mean, are we talking about interest groups, pollution probe, energy probe, Friends of the Earth, and so on? Or are we really talking about the average person at home, the average business person, the ratepayers associations, being able to get information about government's intention to make certain kinds of decisions that are going to affect the environment? I would say that just the sheer volume of decisions that are made in government suggests that anything the public is going to be involved in has to be something that is narrowed down to the significant decisions, scoped down. The question then becomes, fine, let's say we know even what the significant environmental decisions are. Do we let the public have access to every significant policy decision that the Minister of the Environment or that some other Minister of Natural Resources, Minister of Northern Mines and Development, the Minister of Agriculture and Food, every significant policy decision made by one of those ministers should be available for public comment? If so, how? Because as it sits now, many of these policy decisions, the vast majority of them, are made inside government in the very early stages without a lot of public participation, and it's only in the latter stages that the public even becomes aware, perhaps because a bill gets first reading, the public becomes aware of the need to get involved in the issue. So that's just policy. Lots of ministers, lots of ministries, lots of bureaucrats making significant policy decisions about the environment. How do we get the public involved? Regulations. Huge area of responsibility for government to pass regulations that are designed to protect the environment but also manage the way that we consume our public resources, consume natural resources. Should the public be made aware of every intention to regulate? We have the Gazette now, and people sometimes scratch their heads about whether or not that's notice even to the legal profession about the kinds of decisions that are coming along. How do we get the public involved in the government's intention to regulate in certain fields? And by regulate, I mean actually pass regulations that have the force of law. And if we're going to get them involved in those decisions, do they need to be consulted on every environmental regulation or just the significant ones? And if they are just significant ones, how do we define that? And then last and probably most important is this area of instruments, where so many instruments are issued by government, by all of these ministries every year, that it would be, it'd be easy to, or there'd be a temptation to throw up your hands and assume that it would be impossible to get people involved in every single one of these decisions. I don't know if there are people in this room who have had any interest or had any notice in their life about perhaps a neighbor's intention to do something that was going to affect your neighborhood. People tend to get inflamed about things like group homes, or about the decision to close, they're trying to get the, I live in the High Park area, and there's a plant out there that boils down animal parts, I think, or something. But it's a terrible smell on some summer days that tend to get some parts of the neighborhood fairly excited about trying to get the place closed down. Riverdale had a problem with lead contamination of the soil. You may want to think about your own lives not so much as lawyers, but as about your clients and about your own experiences about when have you been interested in an environmental decision that might be made by government. And if you were interested, how would you get notice of it, other than somebody maybe sticking a notice in your mail slot that your neighbor's asking for some kind of variance so they can put the third floor on their house? If those are the decisions that people are interested in, it's going to be very difficult to tell them that the decision's about to be made and to give them an opportunity to participate in it. So our work in the task force really faces these choices. Do we let people participate in all decisions, policy, regs, and instruments? If we do we only let them participate in the significant decisions? If we're going to let them participate in the significant ones, how do we describe that in a way that the public will understand? And even if we can come up with a definition of significant environmental decisions that are in policy fields, in regulations, and in instruments, how do you possibly notify people of the intention to make this decision and give them a timely opportunity to participate in it? And some people will even get into a debate, and it's a legitimate one, about the form of their participation. Should people just be told that there's a decision that's about to be made, and if it's going to have some catastrophic effect on their life, that they are then able to provide perhaps a written response that may or may not affect the decision? Or should, in some cases where the decision is so significant, should there be an obligation within government to actually bring people who are affected by it to the table so that they can participate in the design of the decision itself? It's the difference between consulting the public and allowing the public to participate in the making of the decision. Some people characterize the latter choice, the participation in the decision, as some sort of horrible delegation of democratic power to the public. I mean, how horrifying if people might actually participate in decisions that affect their neighborhoods or affect their businesses. For me, I think that in some cases, there probably needs to be notice to the public, and there needs to be consultation. In many, many cases, there's a need for actual participation in the making of the decision. But the job the task force faces is in picking from all those problems. We need to design some kind of system that gives the public notice and gives them the right opportunity to comment, and that captures the different levels of decision making. There are lots of, I mean, it's not just enough to say they're significant. There are levels of significance for environmental decisions made by government. And the task force spent, I would say, most of its time. We've been meeting since October. We're still meeting now. But we hope to have our report by the end of April for the minister at the very least. What we've designed is a system that will capture the ability to have the public participate in these decisions. And I'll have to remember to tell you at the end of this what the next step is so we can make sure that we've made some of the right choices. The third area that I wanted to tell you about, or the choices that the task force is facing, is this area of access to the courts. We've heard today about the class action giving somebody who has perhaps an otherwise uneconomical claim the ability to get into the court system. But the fact of the matter is we're still talking about plaintiffs who have economic losses. They have some pecuniary loss. There's been some harm. So they have a reason to be in the court system according to our traditional approach to litigation. What about the need for principled litigants in our system? People who litigate about the environment the same way that other people litigate about women's issues, about poverty issues, about the Constitution. People who in some cases have no direct financial connection with the harm or the loss suffered, but are there because they have a principle to fight for. In the constitutional area, the Joe Borowskis of the world who want to litigate over Constitution and protection of the unborn and the Charter, we contemplate that now in the constitutional field. What environmentalists have told us is that we now need to think about allowing a role in the court system for principled litigants who want to protect the environment. Bill 12 talks about that kind of access to the court system. The Ontario Law Reform Commission report on standing recommends that kind of wide open access to our courts. In other words, it's turned it around. Why should we even require people to prove any kind of monetary or pecuniary or other personal interest in litigation? People should be allowed to get into the court system to litigate any cause as long as it's a valid cause of action. I think the approach in the Law Reform Commission report is one of trusting that the right kinds of people will come forward with the right kinds of claims, and you won't see a lot of frivolous litigation. But what the task force was forced to choose is, do we see any role for principled litigants in protecting the environment? And if we do, what should they be protecting? Should they be protecting everybody's land? Should I be concerned as a resident of High Park that somebody in a particular company, was in the paper last week, was fined $300,000 for hiring summer students to dump battery acid into an open pit on a particular piece of property? Now it was a private piece of property, but should I, as a principled resident of the province who has an interest in our environment, be able to go into the court system to complain about the way my neighbor chooses to contaminate his or her land? And if so, how do we make sure that that kind of entitlement isn't abused? Narrowing it down even further is, if we're going to allow principled litigants into the system, do we need to say that maybe the principle is something narrower than protecting the environment? Is the principle that as a resident of the province I have a right to perhaps protect public resources, crown lands, crown waters, the air? Do we all have a principled stake in that aspect of our environment? Because if we do, and I'm able to go into the court system to complain about somebody contaminating that public resource, then there has to be some kind of control, or at least the suggestions made, there should be some kind of control on my access to the court system, not unlike the kinds of controls that are being applied to the ability to use the class action procedure. Those are the choices that have to be made. And the reason in this last case of the principal litigant expanded standing in front of the courts, what environmentalists tell us is that parts of our law in protecting the environment are broken. The public nuisance rule is anachronistic. It doesn't work for the protection of the environment. It doesn't allow people to get into the court system to protect the environment. We hear that there's this restriction on standing is too confining. We also hear that if government is supposed to be looking after the public resources and government doesn't do its job to protect our parks or to protect the crown waters, wetlands, if the government doesn't do its job, nobody else is. There's nobody else sort of following along, trying to make sure the job gets done. And that's part of the law that's broken, we're told. So with that, we have to make choices among those options. The next issue is this whistleblower one. There already is in the Environmental Protection Act a provision that allows someone to blow the whistle on a polluting employer, and certain protections kick in for them. It's cross-referenced with Ontario Labour Relations Board procedures. But the bottom line is that an employee that blows the whistle in certain circumstances cannot be dismissed, harassed, or coerced in some way in connection with their work. It's seen, and not so much as it's not used that frequently, but it's seen as a security blanket or safety valve to ensure that when someone actually does see environmental harm, that they're able to blow the whistle and come forward. There's a parallel set of initiatives underway within government to make sure that public servants can blow the whistle on activity within government. What we need to do is decide in our task force whether or not we need to expand the availability of the whistleblower provisions, whether or not we need to create some kind of right to refuse to do work that will harm the environment, whether we need to create criminal penalties for people who fire employees that dismiss or whether we need to create a criminal penalty for somebody who dismisses an employee that blew the whistle, and whether or not there's a need in the environmental field for the same kinds of joint committees in the workplace that are now seen as a positive development in the occupational health and safety field. So you can see from that we're faced with choices in who has the primary responsibility for protecting the environment, how do we get the public involved in the key environmental decisions being made by government, what kind of access should there be to the court system to protect the environment, and in what circumstances should it be available, and what kind of protections are necessary in the workplace to make sure that employees can speak up when they see this harm. Added to all of that is we got sort of carried away in our work because it's exciting public policy to work on. Are there other things that are wrong with the way we protect the environment? Are there other things that we do that in government or in the way that we make our decisions that can be streamlined or improved so that the system actually works better? Because the Bill of Rights, I don't think, should be seen as some sort of bureaucratic boondoggle that just slows decision-making to a crawl so that business people can't build their plants, get their approvals, and so on, and carry on business in the province in a competitive way, because that seems to be the buzzword for the 90s now, is everyone being able to be competitive globally. And the horror that we hear is that Ontario will become so concerned about protecting its environment that people won't locate their plants here, they won't carry on business here, and it'll be Mexico or other third world countries will get the business, and we won't be any further ahead. We'll have a nice environment, but there won't be anybody working here. Those aren't the kind of choices we face, and I think the task force, given the solid representation we have from business on it and the solid environmental advice we're getting, is that isn't the choice. It's possible to get something in the middle that actually assists government to make the decisions, will assist business to get their approvals and get their licenses and carry on their business in a way that is not harmful to the environment. And for us, I think as lawyers, we want to make sure, and to credit to the Advocate Society and the CBAO on this, their submissions have been very to the point that they are not interested on your behalf in seeing incredible access to our court system that the courts can't handle. There's no sense giving people a whole bunch of rights that they can't afford to use, or giving people a whole bunch of rights that simply bog down our courts. So what we're trying to do in this task force is make sure that the choices are made in the right way so that the Bill of Rights can actually have an impact on environmental decision making and benefit the environment but not close down industry. And so far, so good. For timing considerations, the report we're trying to write and have a consensus by the end of this month. We're having draft legislation prepared as we go along, which means that we should be able to, if everything goes according to plan, we should be able to have a report and a draft bill tabled in the legislature, not introduced, but tabled for public comment in the legislature sometime before the end of June. The session this year will end on June 25th. So sometime before then, Ruth Greer should be able to table the report and the draft bill. Now, that's where you then become involved. I don't know if you had plans for the summer, but if I can make a suggestion, I would say that if this does go according to plan and the report's available, if you're interested in class actions and you're interested in environmental litigation, depending on what choices are made in this task force, there could be quite a strong connection between class actions and protecting the environment. There will no doubt be an impact on your clients. So what I would suggest is, now that you've had the choices identified for you, get the report when it's made available and go through it thinking of these kinds of choices. It's written in exactly the same way that I'm describing it to you today, so it'll all sound pretty familiar. And see if you like the way that we made the choices, because the exercise is not finished when this task force reports. The next step is to take our conceptual framework out to the public, including lawyers, and find out what you think about it. Do you think we made the right choices? Do you think that we put things in the right boxes? Do you think you've got the right kind of access to the courts? Will it help your clients? Will it hurt them? And let us know, because depending on what we hear over the summer of '92, there isn't any reason why, if the support's there, that when the House resumes in the fall session, that this legislation can't get first reading and second reading and get into the legislative process for some very intensive consideration. And it would be nice if there were people, informed people like yourselves from the bar, who are able to come in and say, I like this, I don't like that, you made the right choice here, you made the wrong choice there, because it's the only way we get legislation that works. And these exercises in class proceedings and in designing the Environmental Bill of Rights, I think are dramatic, positive developments in formation of public policy. And just because it happens the way that it happened on the class actions in the EBR doesn't mean that there's no role for the bar. If anything, your role is heightened. So I'd invite you to follow the debate closely this summer if we're able to get our report done in time, so that you are aware of the choices that we made and you're able to comment. If anybody has any questions at all on this, I'd be happy to take a stab at them. No? Okay. The only other thing I'll tell you is that there have been fairly extensive consultations that have been going on parallel to the task force work. As I mentioned, meeting with the CBAO and the mining and the forestry people and all that. We've been able to confidentially double-check the direction of our work with a number of other sources, including places like the Sewell Commission, the Roundtable on the Environment and the Economy. And so far, not letting any big secret out here, so far we think that we've really got something that's quite valuable and that the public won't have any trouble supporting. All of the anxiety that the business world had about the EBR should be lowered significantly. And I think on the environmental side, Bill 12 has been really eclipsed by the work of this task force. We've got something far more comprehensive and far more meaningful than some of the provisions that were in Bill 12. But I look forward to hearing your comments summer, late fall of '92. Thank you. And we won't be back here until 1:30. I think that's when our program starts. Let me just double check.